I'm Carl Loparo with the 1851 Center for Constitutional Law. I want to thank the Ohio Licensed Beverage Association for hosting the event. I'm going to hand it over to Phil with the Licensed Beverage Association. He'll make some brief remarks. And then Maurice Thompson, the director of the 1851 Center for Constitutional Law, will explain the case and its impact.
Thanks, Carlo. My name is Phil Craig. I'm the executive director of the Ohio Licensed Beverage Association. Thanks a lot for being here today. We are here to continue what is a long-standing tradition of OLBA advocacy for retail liquor permit holders in the state of Ohio. In fact, our last effort is actually quoted in Judge Kane's ruling, and we're proud of the representation we do for permit holders here. Smoking, as you know, has been a major blow to the let's call it the bar business. And so we are most happy today that we believe that Maurice Thompson, our attorney in this instance, has punched a hole in that statute. And there's more work to do, but this is a great day for permit holders in Ohio. And I'll turn it over to Maurice Thompson to talk more about it with you.
Thanks, Bill. I'm just going to speak for a few minutes about why we as a nonprofit, the 1851 Center, decided to get involved in this case. In other words, why is there a greater issue that extends just beyond smoking in Ohio? Secondly, I'll discuss what we argued in the case. Thirdly, what the judge decided. And finally, what this actually means on the ground to Ohio's small business owners and to the rest of us. First, the greater principles involved here. First off, at the 1851 Center, we believe in limited constitutional government. We were immediately offended by the political nature of the prosecution of Zeno's. The Attorney General decided to litigate this case through the media and professed that he was going to make an example of Dick Allen and Zeno's in order to send a message to the remainder of Ohio's small business owners on smoking ban issues. Well, we hope that the judge's decision makes an example instead of the Attorney General and of politically oriented prosecutions in Ohio. Secondly, we are concerned about unaccountable administrative agencies, government agencies that can't be elected by the people. We're concerned about them making the law because they don't have the constitutional authority to do so. We're concerned about them taking the law into their own hands, which they also lack the authority to do. We're concerned about them passing the buck and enforcing the law from themselves to small business owners in Ohio simply to save costs and maximize profits to them. Then we're also concerned about the policing for profit that's going on with the smoking ban. The law essentially has deputized these health departments to act as contingency fee lawyers. In other words, 90% of the revenue that they collect from the fines that they assess actually goes directly into their own treasury. And this, of course, creates extremely perverse incentives, and incentives for them to cut corners on enforcement. And that's a major problem in Ohio. Those incentives are entirely foreseeable. Lastly, we're concerned about the issuing of $5,000 fines without investigations. $5,000 is not a small amount of money to a small business owner. In some cases, this is a sufficient amount to wipe out several days of profit, if not an entire week of profit, or in the case of some of our very small businesses, even more. What we argued, first and foremost, was that the smoking ban actually unconstitutionally infringes upon small business owners' property rights in Ohio, at least as applied to small bars. But also, we argued that the entire way that the Ohio Department of Health had been enforcing the law is also unconstitutional because government agencies can't make the law. And that's exactly what we argued that ODH has done in this case. On this latter point, the court agreed with us. They ruled a number of things. They ruled that the Ohio Department of Health and its local health department designees have cited Zeno's and others without regards for whether they actually have permitted smoking. They argued, or the court ruled that the court's decision is addressing an entire enforcement policy which was department-wide, which is extremely significant and critical to the ruling. Thirdly, the court held that ODH has never properly investigated prior to levying these smoking ban fines, which again can get to $5,000. Next, ODH greatly exaggerated the situations where they were authorized to issue these types of fines. And finally, the court did know that this is offensive to fair play and justice, and that's actually a quote from the decision. And accordingly, it wiped out Zeno's fines, which were $30,000, is what the Attorney General claimed that Zeno's owned in this case, which was owed rather. And this is amongst the largest amounts owed in the state, which is perhaps why Zeno's was chosen for this prosecution to begin with. The court further, therefore, holds that Zeno's will not be seized and liquidated, as the Attorney General has been attempting to do to collect these fines. What this means on the ground for business owners and for all of us is a number of things. First off, it means that the Ohio Department of Health is going to have to reevaluate its enforcement policy. What's clear is that the current policy, which has been statewide, has been implemented since the beginning of the smoking ban over the last 3 years, is in fact unconstitutional, because the Department of Health essentially made up the rules of the game as it went along and cut corners when it came to citing small business owners. So this means the ODH is going to have to reevaluate its policy and actually investigate when it shows up at a small business, determine whether the individual is notified of the smoking ban before he began smoking. If so, the individual is liable rather than the business owners. That means that the Department of Health is going to have to do something that they have never done before. They're going to have to actually investigate on site. They're going to actually talk to the individual who is smoking, which is something that heretofore they have entirely avoided. In fact, an individual has never been cited for smoking in the state of Ohio in the 3 years of the smoking ban. Only business owners have been cited. And this, of course, passes the buck to a third party who may, in fact, be innocent. As was reported by the dispatch, I believe, on Monday, there are a significant number of fines that have been levied in the state. I believe $1.2 million in fines have been levied. $400,000 has been collected. This decision calls into question the fines collected and the fines outstanding. It is our position that state business owners who have fines outstanding are not required to pay those fines because they were fined pursuant to an unconstitutional enforcement scheme. It is further our position that based upon the ruling, those who have already paid their fines may well be entitled to a refund. And this may apply to all of our owners who have paid fines in the state, or small business owners for that matter, or it may at least apply to most of the business owners who have complied with the law to the extent that the court outlines in its decision.